Kwame Kilpatrick checking account?
Yes.
And what does that amount to?
It's over $100,000.
Received.
Where are you
Statement
talking about?
beginning balance, I'm sorry, sir, where it says 20,000?
Oh, 20,253.
All right, so that's the statement beginning balance.
Mm-hmm.
As to the amount of money that's there as a 415
In that account.
in that account. You see that?
Yes.
And that's a joint account between you and your wife, correct?
Yes.
And during that month, there were additions and subtractions of $101,000.
I disagree with this entire document on that kind of information. We'll stick with the beginning balance, though. This document is very misleading and wrong.
Your Honor, I'm going to move the admission then of People's Exhibit number 33, which is a joint checking account ending in 2630. That was provided to the court previously, and to Mr. Schwartz. People's Exhibit number 34, which is the Carlito checking account ending in 2648. 34. People's Exhibit number 35, which is the Kwame Kilpatrick checking account 1956. People's Exhibit number 36, which is the Carlito Kilpatrick checking account 8981. And People's Exhibit number 37, which is the Carlito Kilpatrick savings account 8730. I'm not sure if I did that last time. I would move the admission of the certificate from the keeper of records, which is 32A, which is a redacted document. I did show the original to the court and Mr. Schwartz last time. The 32A is the redacted document. It doesn't have all of the account numbers. It just has the 4 ending digits.
That's enough.
Can I see that?
32?
Off the record for a few minutes, Mr. Schwartz.
No, Your Honor, I'm ready to proceed. Your Honor, with regard to this, I want to object to this on the basis that this was improperly subpoenaed in the way that it was. Subpoenas, when we have subpoenas, are returnable to the court. This appears to be returnable to Mr. Spada at the prosecutor's office.
No, this is a
It was not given to me at the time that it was sent off to the bank, and accordingly, since I had no opportunity to object, and since the proper rules are not followed in this case, I moved that the fruits of that subpoena not be allowed in this case.
Is that your only objection?
Yes, sir.
Well, I think that you've had every opportunity to object, at least since the last hearing. I've received nothing in writing indicating to object if anything was subpoenaed. You received copies of those documents before the last hearing and never raised an objection until this very moment.
That's because I don't make objections until somebody moves to put them into evidence. That's the way it's supposed to be done under the rules, not interim between cases.
Your Honor, just so the record is clear, we discussed this last time. This is a restitution hearing, not even subject to the rules of evidence to some extent. Obviously, we're trying to, as best as we can, the rules of evidence don't apply. This is an evidentiary hearing to which the rules of evidence don't apply. The court signed the subpoena. This was a subpoena signed by this court because the defendant violated this court's prior orders, required him to produce these documents. We didn't want to have to do, I mean, had the defendant provided the documents, we would not have to go to this extraordinary measure to get these records. He was ordered to do it, he didn't do it, And we've had to go down trying to trace these records so we can find out exactly what his assets are. And now that we've seen them, we know why he was hiding the assets, because clearly he had, and he spent over $755,000 within a 1-year period. This is money that he and his family have spent. $755,000. Well, he's coming to the court saying, I don't have $6 to pay restitution. I have to borrow $1,000 from my friends to pay restitution, when he, in fact, is spending money like he's a multimillionaire. And telling this court that he doesn't have assets to repay the city of Detroit.
You're going a little bit beyond the motion and the argument. So, did you want to address that?
I thought I did.
Well, you
Ron.
did. Do you want to add anything else, or?
No, I think it's the records.
Your Honor, in addition to everything else, she came with an ex parte subpoena in the middle of this case. This is just outrageous, Your Honor. According to what I saw there, that subpoena, I believe, if I'm not mistaken, was dated October 20th, when it was supposed to be returned after we started these restitution proceedings, which started way back in or about March or thereabouts. And for her to come to this court ex parte, and I don't know that Your Honor was even aware that she hadn't informed me that she was coming, is just outrageous. And for her to make all the rest of these speeches over here, I'm not going to belabor it, and go out and speechify for the press that she can grandstand is wholly inappropriate.
This, Mr. Spada.
Your Honor, would you like to address the court?
Yeah. When we originally started this restitution hearing, I faxed a subpoena to defense counsel in care of Carlita and Kwame Kilpatrick asking for their bank records. We did not get anything. Nothing. He said he provided everything to the probation department. If you remember, he had his press conference saying he'd given us everything. I then came to the court and got a subpoena signed by Your Honor to get those records. They were never provided to us. To stand here now and say they're shocked by their own bank records is ridiculous.
Your Honor, I don't represent Carlita Kilpatrick, and I never have. And I advise Mr. Spada of the same. For him to go out and now make these claims, I think indicates really that this proceeding is something other than what has been advertised to the public at large. This is simply an opportunity to bash Mr. Kilpatrick and anybody who is associated
Mr.
with him.
Schwartz, you know, you give your own speeches too. Both of you give speeches. The objection is overruled. It's highly relevant, and I agree with Mr. Spada. There was supposed to be disclosure of the bank accounts, and it was not disclosure. That prompted the prosecutor's office to ask for the subpoena, which I signed, and now we have the records. It's exactly what we need to look at in this case, because there was not full disclosure. Maybe your client can explain why there wasn't, why he gave this court only certain documents from his bank accounts and his wife's bank accounts, and maybe there's an adequate explanation, but those documents are highly relevant. Those are his bank records. You may proceed, Mr. Schwartz. As far as the documents being, I don't think I said it on the record, but I would then allow the admission of people's 33, 34, 35, 36, 37. Is there anything else?
The certificate, Your Honor, 3280.
That is the redacted certificate with the account numbers.
All right. 32A will also come in. And obviously, I want to see all the exhibits that are going to come in to make sure that they are properly redacted. And I don't know if you went over those with Mr. Schwartz at all, but certainly I don't want any information into the public that is not relevant to this proceeding.